Podcast Bites, powered by IndiaLaw LLP. I'm your host, Pranjal Maheshwari. In today's episode, we discuss a recent judgment of the Bombay High Court in Siddhesh Pradeep Satpute versus State Bank of India and others, pronounced on 16 June 2026. The judgment deals with the precise but important question under the Sexual Harassment of Women at Workplace Act 2013, commonly known as POSH Act. Can an alleged incident in a shared public auto rickshaw while a person is traveling to work be treated as an incident at the workplace for the purpose of an internal committee inquiry? The facts, as recorded in the judgment, arise from a daily commute. The petitioner was an employee of the State Bank of India and had been working with the bank for around 14 years. He was residing at Navi Mumbai and would travel to his office at Bandra Kurla Complex, Mumbai. On 24th March 2023, he travelled from Kurla railway station to BKC in a shared auto rickshaw. The petitioner, respondent number 3, and another passenger were seated on the rear seat of the auto rickshaw. According to the petitioner, the seating was cramped and uncomfortable, and the auto rickshaw ride was bumpy due to the condition of the road. The petitioner was that, in those circumstances, his left hand may have touched the bag carried by the respondent number 3 on her right arm. The matter escalated during the ride. As recorded by the court, respondent number 3 alleged inappropriate touching. She stopped the auto rickshaw near American Embassy at BKC and, according to the petitioner's version, sprayed pepper spray in his eyes. The police was called and a case was registered against the petitioner under Section 354A of the Indian Penal Code 1860. Separately, respondent number 3 also lodged a complaint with the Internal Complaints Committee of her own company. The committee forwarded the complaint to State Bank of India. The petitioner's employer, SBI's internal committee, then conducted an inquiry. By an order dated 29 August 2023, the internal committee found the petitioner guilty of sexual harassment and recommended action under the service rules. The petitioner challenged the internal committee's order before the Bombay High Court. His principal argument was not on the factual merits of whether the allegations were true or false. Instead, his argument was jurisdictional. He contended that the alleged incident had not taken place at the workplace as defined under the POSH Act. According to him, a shared auto rickshaw is public transport. It was not transport provided by SBI, nor it was transport provided by the employer of respondent number 3. Therefore, he argued, SBI's internal committee had no jurisdiction to entertain, inquire into, or decide the complaint under the POSH Act. The court examined the statutory framework. Section 2A of POSH Act defines an aggrieved woman in relation to a workplace as a woman of any age, whether employed or not, who alleges that she has been subjected to an act of sexual harassment by the respondent. Section 9 allows an aggrieved woman to make a written complaint of sexual harassment at the workplace to the internal committee, where such committee is constituted. The crucial provision in this case was Section 2O, which defines workplace. Clause 5th of Section 2O includes any place visited by an employee arising out of or during the course of employment, including transportation by the employer for undertaking such journey. The petitioner submitted that the definition cannot be stretched to cover every place or every mode of travel merely because a person is on the way to work. His argument was that the statute specifically refers to transportation by the employer. Therefore, where the alleged incident takes place in public transport, independently chosen by the commuter and not provided by the employer, it cannot automatically become a workplace under Section 205 on the basis the petition submitted the internal committee's order was without authority of law and liable to set aside. The State Bank of India, on the other hand, defended the internal committee's jurisdiction. It argued that the expression workplace had been correctly interpreted by the committee. It further submitted that by virtue of Section 2A, 9 and 11 of POSH Act, the internal committee had jurisdiction to receive and inquire into the complaint. The bank's stand was that the committee could consider whether the incident took place at the workplace while conducting the inquiry. The Bombay High Court first noted why it was entertaining the writ petition despite the fact that the petitioner had also filed an appeal. The court observed that wherein jurisdiction issue is raised, the existence of an alternate remedy does not necessarily prevent the High Court examining the matter in writ jurisdiction. The court then focused on the language of Section 205. It held that for transportation to fall within the meaning of workplace under the clause, the transportation must be provided by the employer. In the present case, both the petitioner and the respondent number 3 were traveling in a shared auto rickshaw from Kurla railway station to BKC. The court specifically recorded that the transport had not been provided either by the petitioner's employer or by the employer of respondent number 3. On that reasoning, the court held that the shared auto rickshaw did not fall within the definition of workplace under Section 205 of the POSH Act. Consequently, the alleged incident had not taken place at a workplace for the purposes of the POSH Act. The court held that SBI's internal committee could not entertain a complaint of sexual harassment if the alleged harassment had not taken place at the workplace. Therefore, the internal committee had no jurisdiction to entertain the complaint or pass the order dated 29 August 2023. A very important clarification must be highlighted. The High Court did not decide whether the petitioner had or had not sexually harassed respondent number 3 in the shared auto rickshaw. The court expressly stated that it had not gone into the merits of the controversy. The issue was left open to be dealt with in accordance with law in an appropriate proceeding. The distinction is critical. The judgment is about the jurisdiction of the internal committee under the POSH Act, not about the truth or falsity of the allegation itself. The writ petition was allowed. The Bombay High Court set aside and quashed the internal committee's order dated 29 August 2023. The rule was made absolute and there was no order as to the cost. There are three takeaways from this ruling. First, the jurisdiction of an internal committee under the POSH Act is tied to the statutory concept of workplace. The committee must examine whether the alleged incident falls within the framework. Second, the expression transportation by the employer in Section 205 has significance. Public transport used by an employee for commuting does not automatically become a workplace merely because the employee is traveling to office. Third, the judgment does not dilute the seriousness of allegations of sexual harassment. It only clarifies the proper forum and the jurisdictional limits of an internal committee under the POSH Act. This brings us to the end of today's podcast bites, powered by IndiaLaw LLP. I am Pranjal Maheshwari. Thank you for listening. Until next time, stay informed and stay compliant.